Welcome to the Professional Legally English lesson. Today, our lesson is contract law. We will delve this into an exciting topic with the exercises and tasks, with the best solutions and detailed explanations. This lesson is for students and teachers as well. If you would like to get more such kind of video lessons, kindly ask you to subscribe my YouTube channel, support my YouTube channel, and also wise, kindly ask you to like my video lessons, and I advise you to join my Telegram channel for easy downloading all the materials of our video lessons. So here, that's evident. We do have three extracts that we need to read first and foremost, that the three student lawyers made following lecture on aspects of contractual breach. So first extract is, the lecture was a bit complicated, but I think I got the main idea. Where there is a breach of contract, there are a lot of different sorts of remedies available to the innocent party. The types of remedies may vary depending on the type of breach and also the applicable law. For instance, the CISG, the UN Convention on Contracts for the International Sale of Goods, says that if there is a fundamental breach, then the contract may be avoided. In other words, the breach is so serious that the other party can't get what he expected under the contract. What's important is that if the party in breach or a reasonable person of the same kind and in the same circumstances couldn't have foreseen the damage to the other party, then the breach is fundamental. The second extract is, yes, it's all about foreseeability, isn't it? We have to look into the future and work out what might be the most likely result, then work backwards. It appears that foreseeability of a loss affects both fundamental breach and non-fundamental breach. If the loss or damage for the affected party, or as our lecturer put it, detriment wasn't foreseeable and it can be proved, then lack of foreseeability is a ground for excuse. However, the burden of proving foreseeability rests with the breaching party. So, in a nutshell, if what happened couldn't have been predicted and the breaching party can prove this, then there is no fundamental breach, right? Third, I think so. I can understand that the type of breach seems to determine the damages that can be looked for, but it's difficult to get clear guidance on what actually constitutes a fundamental breach, which is really pretty fundamental, wouldn't you say? The lecturer suggests that the vagueness in Article 25 of the CISG is because of the differences which exist across all the definitions of fundamental breach in the various legal systems. This seems to be reason why the drafters couldn't agree on the type of breach that leads to avoidance of the contract. All the convention does really is provide interpretation guidelines, which surely leaves lawyers a bit in the dark. Don't you think so? And now we need to match these options with our extract. A option is belong to the second. Lawyers often have to use prediction in their work. B option again to the second extract belong to. It's up to the breaching party to show that no damage was foreseeable. C option belongs to the first extract. A breach is fundamental if a reasonable person would have predicted the damage. D option belongs to the third extract. lawyers have to weigh up what might constitute a fundamental breach. E option belongs to the, again, third extract. The CISG isn't clear about this point because different legal systems interpret fundamental breach differently. F option belongs to the second extract. Loss forcibility doesn't only affect fundamental breach, and G option belongs to the first extract. Remedy options depend on the type of breach. So the following tasks is belong to the language word vocabulary. So we need to match the expressions to the formal meanings. I think I got the main idea. Most important point. That's professional legal English expressions. In other words, to express it in a various way. It's all about, it mainly concerns. So, in a nutshell, to summarize, it's really pretty fundamental, wouldn't you say? I'm sure you agree. And six, it surely leaves lawyers a bit in the dark, don't you think? That's A option, not knowing what is happening. So that's all for our short lesson regarding professional legal English course. Thanks for watching.